Hi folks, Rod Genders from Genders and Partners Solicitors here with you again today. And today's video is from our estate planning division and shows you how to avoid a costly family catastrophe.
Hi folks, I'm Rod Genders from Estate Planner. I'm a senior experienced lawyer specialising in estate planning, and I'm here today to talk to you about how you can avoid a costly family catastrophe by protecting yourself, your family and your assets using modern integrated estate planning. You'll discover the hidden truth about wills and estate planning, and this is information that the big insurance and trustee companies don't want you to know about. But it's knowledge and strategies that your family need you to understand right now. Without the correct legal protection mechanisms in place, you and your family and your assets are at risk. If you don't make sure that the right people have the right power at the right time, then you know what's going to happen? The wrong people will get it. If you're not careful, your hard-earned assets could wind up in the hands of creditors, litigators, gold diggers, or even the government. So I'm going to share with you today some home truths that some very big companies don't want you to know about. And I may only be able to have this information online for a short time, so watch this while you can. Today I'm mainly going to be concentrating upon the areas of problems that people seem to encounter when they look at creating an estate plan, and I'll give you the solution that you need to know about and what to do right now. So let's get underway. Most people don't plan ahead. They don't like to think about the bad things that could happen to them or their family, but by doing nothing, they are making a choice. They are choosing to be unprepared. You know that you can't apply for insurance after the disaster has already struck. Well, it's the same thing here. You can't create estate planning documents if you've already lost your capacity. If you don't put your affairs in order now, it could be too late. So failing to plan has exactly the same effect as planning to fail. If you don't take action today, how will tomorrow be any different? So let's have a look at the most common problem areas. Many people don't have a will at all. They may perhaps try to do it themselves using a kit will. They might go to an executor or trustee company. They might not have their documents integrated and properly coordinated, so they're working together, and they probably haven't kept their documents up to date. Let's take a closer look at each of these problem areas. Every Australian over the age of 18 needs a valid legal will, and without one, the government of the state where you die will determine who receives your estate. Every state government has its own little statutory formula for determining how to distribute the estate of a person who dies without a will. And those formula vary from state to state, from place to place, and from time to time. And it almost certainly won't be who you would expect or want to inherit your assets. So you need to create your own will. But if you try to do it yourself, you need to be very, very careful. Kit wills that are advertised by insurance companies and other places are really just expensive stationery. There's no legal advice, there's no backup or support, there's no adjustment for your personal circumstances. And if you check the fine print on those will kits, every single one of them contain a disclaimer that says that you should take legal advice first. It is really easy to make serious mistakes using those will kits, and the main problem is that the errors that you make in those will kits won't become apparent until after you're gone, and then it's too late for you to correct them. It'll be up to your family, who'll have to deal with the mess and the heartache of trying to fix up the problems that you created. And it's very expensive to try to fix those mistakes, and it might not even be possible. You know, most people wouldn't dream of installing their own air conditioner or even installing their own toilet. And yet somehow they've been fooled into thinking that it's a good idea for them to do it yourself, the most important legal document in their life. and with their entire family's future depending upon it being done properly. It doesn't make a lot of sense. Now, if you go off to a trustee company to get a free will, then they will insist that you appoint them as an executor of your estate. And that allows them to charge you a percentage, a commission of your estate as their fee. And that fee will typically be thousands of dollars more than a specialist lawyer would charge for the same work. So their free will isn't such a bargain after all. There's no such thing as a free lunch. Now, not keeping your documents up to date is another serious problem. This is not a set and forget exercise. It's essential that you keep your documents up to date. There are new laws and surprising court decisions happening all the time. Frequent changes to the tax and superannuation structures, family court decisions that interfere with people's wishes. You need to stay on top of these developments to keep your estate plan effective. And your own personal circumstances will definitely change throughout your life, and those circumstances will also affect your estate plan. Divorce, marriage, changes in job, your own inheritances, a second marriage, stepkids, a long-term illness, all of these things can and will affect your estate plans. And importantly, the older your estate planning documents are, such as your will, when you die, the more likely it is to lead to problems after you're gone. So if there's quite a gap between the date when you create your will and the date that you die, the greater the gap, the greater the chance that the document will be perceived to be no longer relevant to your then circumstances, and it will be more likely to be susceptible to a successful challenge in court. So don't fool yourself. Don't keep risking your family's future by putting this off, or you and they will end up regretting it and paying for the consequences. Here's what you need to know to move ahead. Estate planner is a wholly owned division of the oldest law firm in South Australia, Genders and Partners, founded in 1848. And we provide modern, effective, integrated estate planning packages for our clients that help you to take control of your own affairs and to put them in order. And that allows you to protect your loved ones and your assets. Our plans are not expensive, and we have payment plans and options available. We're a lot better value than commission-based trustee companies, and very much more effective and less expensive than trying to fix mistakes in do-it-yourself documents, assuming that the mistakes can even be fixed.
I hope you enjoyed today's video. If you did, please leave us a comment. We'd love to hear from you. Share it with a friend and hit the like button.